Picture waking up to learn that the rights you thought were guaranteed aren't actually consistent everywhere. That the freedoms promised by the Bill of Rights, America's bedrock, can be robust in one state and hollow in another. That justice, or the lack of it, hinges not on what happened to you, but on where it happened. Not on the facts, but on which federal court hears your case. That wasn't a dystopian thought experiment. Until last week, it was the lived reality for millions of Americans. A 9-0 Supreme Court ruling is exceedingly rare. In an age dominated by 5-4 splits, sharp dissents, and ideological trench warfare that has turned the court into what many see as a partisan arena, unanimity is almost extinct. Over the last decade, fewer than 15% of cases were decided without disagreement. When every justice, from the most conservative originalist to the most progressive pragmatist, locks arms, it's not because the issue is easy, it's because something has gone profoundly wrong. That's what happened this week. In Barnes versus Felix, all 9 justices, liberal and conservative alike, set aside ideology and delivered a single, unified ruling that will reshape Fourth Amendment law, police accountability, and the real-world meaning of constitutional protections nationwide. No dissents, no concurrences, no hedging footnotes, just total agreement. The court didn't merely resolve a dispute, it dismantled a doctrine that had shielded questionable government conduct for decades, a rule so influential it determined whether justice existed at all based solely on geography. This decision marks the official end of what courts called the moment of threat doctrine, and it took the death of a young man, Ashton Barnes, killed over a $6.45 toll violation to force the Supreme Court to act. If you've ignored this case, you shouldn't anymore. Its impact will reach every police encounter, every use of force investigation, and every Fourth Amendment claim in America for generations. For years, something troubling unfolded quietly inside the federal judiciary. It wasn't flashy, it didn't dominate cable news or spark viral outrage. It lived in dense appellate opinions and obscure procedural rulings, places the public rarely looks. But the consequences were life-altering. Consider this. 2 identical police encounters, same facts, same choices, same outcome. One happens in California, the other in Texas. Before this ruling, the constitutional analysis could be radically different, not because the Constitution changed, but because judicial interpretation fractured. Your Fourth Amendment rights, the protection against unreasonable searches and seizures, weren't uniform, they were regional. That alone should stop you cold. The Constitution is supposed to mean the same thing in Maine as it does in Texas, in Washington as in Florida. Equal protection isn't supposed to depend on a zip code or a courthouse address. The 14th Amendment exists to prevent precisely this kind of inequality. Yet that's exactly what was happening. Most federal courts applied the long-standing totality of the circumstances test. Judges examined the full encounter, why the stop occurred, how officers behaved, whether they escalated the situation, ignored safer options, or created danger through their own decisions. This approach wasn't radical. It flowed naturally from decades of Supreme Court precedent and basic common sense. If you're judging whether government action was reasonable, you look at everything that led to it. But several influential circuits, the 5th, 2nd, 4th, and 8th, adopted a drastically narrower rule. They called it the moment of threat doctrine. Under that rule, courts were told to wear what Justice Elena Kagan later dubbed chronological blinders. Everything before the final seconds of a use-of-force incident was treated as legally irrelevant. Time was frozen, context erased. Policy violations didn't matter, reckless tactics didn't matter, escalation didn't matter. Ignored de-escalation training didn't matter. Even if officers created the danger themselves, courts often refused to consider it. The only question became this: in the last second or two, did the officer perceive a threat? If the answer was yes, the case often ended there. Qualified immunity attached. Lawsuits were dismissed, sometimes before discovery, sometimes before trial, often before a jury ever heard the story. Justice became a matter of geography. In Houston, a case was often dead on arrival. In Los Angeles, the same facts might reach a jury. In New Orleans, officers were shielded. In Chicago, victims had a chance. This wasn't theory, it was measurable chaos. From 2018 to 2023, federal appellate courts issued more than 240 published opinions wrestling with this exact issue and disagreed over 60% of the time. Judges reviewing similar facts couldn't even agree on the framework for analysis. That's not healthy disagreement, that's constitutional disorder. The fallout went further. Police departments lacked clear standards, training academies couldn't offer consistent guidance, officers working near circuit borders faced different legal consequences for identical conduct. Even the federal government exploited the confusion, advancing one legal theory in one circuit and the opposite elsewhere. Same constitution, same government, different answers. The human cost was immense. Families seeking accountability weren't turned away because their claims lacked merit, but because they lived in the wrong place. Then came a routine traffic stop in Texas. In 2016, Ashton Barnes was pulled over in Harris County for unpaid tolls, $6.45. A trivial matter. It should have ended with a citation or warning. Instead, within a minute, Deputy Constable Roberto Felix drew his weapon. Within 90 seconds, he made a decision widely condemned by police law enforcement experts. He jumped onto the door of Barnes's moving car. Moments later, Felix fired 2 shots through the window. Ashton Barnes was dead over a toll violation. According to the record, Barnes was trying to leave. He was unarmed. He wasn't threatening the officer or driving at him. At most, he was fleeing, a minor offense that does not justify lethal force. Felix's choice to leap onto the vehicle, a maneuver discouraged by police training nationwide, created the danger he later claimed justified the shooting. When Barnes's family sued, the courts ignored nearly everything that mattered. They focused only on the final seconds because Felix faced danger at that instant, a danger of his own making. The killing was deemed reasonable. Case dismissed. No jury, no accountability. The Fifth Circuit affirmed, bound by its own precedent. The Supreme Court said enough. Out of thousands of petitions each year, fewer than 70 cases are heard. Barnes versus Felix broke through because it exposed a nationwide fracture in constitutional law, one too serious to ignore. The question was simple. When evaluating police force under the Fourth Amendment, must courts consider the entire encounter or only the final moment? The split was undeniable. Some circuits said only the last seconds mattered. Others required a full context analysis. The rest were hopelessly inconsistent. More than 40 organizations filed briefs, from libertarians to civil rights groups, from former prosecutors to police chiefs. Groups that rarely agree reached the same conclusion. The moment of threat doctrine was indefensible. At oral argument, skepticism came from every corner of the bench. Justice Kagan asked whether officers could provoke danger and then claim self-defense. Justice Gorsuch questioned the doctrine's historical basis. Chief Justice Roberts highlighted the absurdity of ignoring an officer's own escalation. On May 15, 2025, the court ruled 9-0. Writing for the court, Justice Kagan was blunt. You can't assess the totality of circumstances while wearing chronological blinders. You can't judge a story by its final sentence. Courts must examine the full sequence. Officers are accountable not just for force, but for the decisions that led to it. Self-created danger counts. Unnecessary escalation counts. Ignored training counts. An officer cannot manufacture a threat and then use it to justify deadly force. The Fourth Amendment, the court wrote, demands more. The ruling doesn't abolish qualified immunity, but it makes it harder to misuse. It restores uniformity. It validates de-escalation. It empowers juries, and it sends a clear message to lower courts. This doctrine is dead. Barnes versus Felix will reshape policing, litigation, and constitutional law. But its core lesson is simple. Context matters. Rights don't begin in the last 2 seconds of an encounter. They exist from start to finish.